23(2) aside. Let us stick to the NCT guidelines. NCT guidelines.
Clause 10.
Clause 10. And I'll read that clause 10, my lord, in a moment. But your lordship, and secondly, my lord, this is the first submission. Secondly, expansion of zone of consideration.
जवाब देना.
Expansion of zone of
सुप्रीम कोर्ट में जवाब 1 to 5 का जवाब सुप्रीम कोर्ट.
Yes, my lord. Kindly come to my lord para A through para 6 onwards.
Yes.
Sub Roman 1, your lordship may skip, my lord. This is sub clause 2 at page 3 also, my lord, is the background. Kindly come to Roman 3. If your lordship just permit me to read Roman 3.
Yes.
By the letter of so and so NCT frame guidelines from clause 10b of the guideline of NCT for conducting teacher, it appears that the state can consider TET examination qualification as the qualification for the to be appointed as state of Jharkhand. So that is permissible under the Act. So let me stick to this only for the time being for your lordship kind consideration. That NCT guideline, my lord, which flow from the RT and they are, my lord, to be followed by the states uniformly, that itself extends the discretion to the state government in what manner under. So our case, my lord, for this decision of permitting the Ctet candidates and, my lord, the other state candidate is permissible under clause 10 itself.
No, then what would be your contention as you were saying that if we see this, then this doesn't apply?
No, Lord, I am saying that let us assume there are two submissions, my lord. First submission, your lordship said, was never before the High Court, so I am keeping it aside. That 23(2) only talks of courses as well as training, which, my lord, that would not be. That is an eligibility test, so therefore it would not fall under that entire mechanism.
No, Mr. Maninder Singh, once you can't be appointed without having that certificate, you don't say it is a qualification, but it is a certificate. All right.
It's eligibility, yes, my lord.
Once you can't be appointed.
Yes, my lord.
So why it is not a qualification?
Now supposing, my lord, I am 17 years of age, right? And eligibility is 18. So I am not eligible.
Age is a different.
Yes, something more, something more. It is not a degree on which I can rely.
This is a qualification.
If your lordship may kindly permit me to read one line of the.
This is mentioned in the essential qualifications.
Therefore, I don't want to go into that for the time being. But
that's all right.
Kindly see, my lord, for only moment in this counter affidavit where the TET rules are placed. Kindly just give me one moment. Page 29 in this counter before your lordship where the TET rules have been placed. We start at page 21. Kindly come to 29, rule 11. And this is not under any challenge because this was not the issue. I am only bringing it to your lordship kind notice. 29.
That's right. If you pass graduation.
Yes, my lord.
Right? Can you say you should be given employment?
No, my lord.
No.
Lord, that sort of.
It's kind of that thing only.
Lord, that is what.
This will not entitle you to appointment. You will be eligible for consideration. That's all.
I'm saying, but my lord, your lordship.
This is provided in the qualification clause.
I'm not, my lord, that is the position, my lord, which your lordships have seen. I'm only saying, my lord, if the words which have been used in the section 23(2), the entire emphasis is on the courses or training. I'm not
your stand even before Supreme Court.
Not
your stand even before Supreme Court. We can understand that you would have said something in Supreme Court.
Lord, I do not want to, my lord, but
no.
My lord, ultimately, my lord.
No, this is not.
My lord, your lordship.
The intent of section 23 subclause 2 is very clear.
Yes, my lord.
It is of twofold.
Yes, my lord.
Where a state does not have a adequate institution offering courses or training in teachers education or teachers possessing minimum qualification as laid down under subsection 1.
Lord, I'm not bothering.
I'm not available to sufficient members.
Lord, I'm not bothering your lordship. I'm saying that this is for the time being. Lord, clause 10 I am relying.
Yes, that will come to clause 10 now.
226.
226 of
Come to clause 10.
Yeah, but
So your first contention is primarily is not tenable.
Lord, I am not raising it down, Lord, Your Honor.
All right. We will take it as a not raising.
Lord, I am not, because then I have to.
We will take it as a not raising. You have said not raising.
Yes, Lord, 226.
But Mr. Maninder Singh, you had taken us up to the Allahabad, basically going to Jharkhand, now back to
I
Delhi
have
again.
taken your Lordship.
Back to Delhi only now.
Your Lordship may kindly now come to 226, 22 is that, my Lord, 11th,
Yes.
February 11th. And kindly come to, my Lord, applicability at 226, clause 10.
So these are the guidelines issued by
The NCTE.
NCT. All right. Come to 10.
And, my Lord, only for the, because I am going to rely on two judgments of this Honorable Court which have dealt with the 9. So just make a note of clause 9. And then, my Lord, the Honorable Court has laid down certain principles. I'll just read few paragraphs from two judgments.
All right.
Now kindly see 10. Applicability. State conducted by the central government shall apply to all schools referred to in subclause 1 of clause A of section 2 of the RT Act, which are, my Lord, schools run by the central government. So, my Lord, therefore, central government schools, obviously the central government has provided its own debt, it will always be applicable. That is what the NCT also says. Debt conducted by a state government, UT with legislature shall apply. So state is, my Lord, has been put at par for these purposes with the UT which has a legislature like Pondicherry or Delhi. A school of the state government, and my Lord, your Lordship may just keep that in mind, there is word A and there is word D. In given circumstances, my Lord, in a statute, we would have bothered your Lordship, A means any or D means a particular. Just keep that in mind. I am not.
So this was raised by Mr.
Yes,
Gopal.
so therefore just keep that in mind. I would say, my Lord, if that is to be considered, then it is to the contrary, I'll show that how. That conducted by a state, here A would mean any. That's my respectful submission. In this provision, which is not a statute, I am conscious of it, but since the argument is rare, a state would mean any, and would mean every. It is not the state who is conducting the exam. Kindly consider that, my Lord, that's my humble, respectful submission. A would mean any. So, my Lord, any state is a test conducted by any state or UT with legislature, this is the class. It is not restricted to what your Lordship are considering Jharkhand.
All right. Go ahead.
Oh, to Delhi.
Go ahead, Mr.
Now kindly see further. A school, and then it is, this A is again any.
Sometime for a teaching, it is very good that we will take your teaching.
Now for me, for learning, Lord.
Sometimes it is always.
But we request you to
Nobody
take
said
it right.
such arguments comes, na?
So,
So
Lord,
in boggling the mind from this side to that side to this side. Huh?
we are only.
All right, please.
Assisted your Lordship, Lord, in any
No, all
case,
right, all right.
Lord, from this side, our responsibility is much higher. For the state to assist the
Please go on.
Now, Lord, a school would mean any school of the state, government, UT with the legislature. So it is referring to every school in that state with UT legislature. And a local authority referred to in subclause 1 of Lord that section 10 where Lordship have found that the schools, my Lord, definition of schools and appropriate government. My Lord, your Lordship can keep that with your Lord.
Definition clause.
Yes, my Lord.
Right.
In subclause 1 of section 2E, then a school referred to in subclause 2 of clause N of section so and so in that state UT, a school at 1 and 2 may also consider. Now this is may also mean my discretion
Yes.
and discretion of every state, including me. It is a vestige of a discretion. Let me assume, my Lord, NCT is the final authority for 23(2) for its interpretation. I am assuming for the sake of argument. Then this leaves a discretion for every state. May consider. What is may consider? And my Lord, the background and the foundation is bother your Lordship in some other case is the federal structure for the subject of education. Primary education is always with the state. Kindly see, my Lord, a school at 1 and 2 may also consider eligibility of a candidate who has obtained Ctet certificate awarded by another state UT with the legislature. This is first of all a discretion. At a lower pedestal, it is an enabling provision.
This is for other state or UT with legislature, not the central government.
I'm not, yes, Lord, that 1-2 is only this 1-2 here.
Yes.
Just above. You're absolutely right.
You have made eligible the CTET.
Exactly. No, my Lord, CET is
Correct.
not a Tet of any other state. Kindly see, my Lord. A school may also consider anyone who has obtained that certificate awarded by another state.
State,
Of your
not
legislation.
center.
I'll
Number one.
I'll go further.
This proviso kind of a thing is only with clause B.
But it is for clause B and 1 and 2 in B.
Yes, yes.
Your Lordship
He is talking about state only.
So this discretion is with me. That is
Only for state, not center.
yes. In addition to my Tet, I can also consider
Any other state.
this is left to me.
Fine.
Please see further. In case a state government UT with legislature decide not to conduct a TET, a school at 1 and 2 would also consider TET conducted by the central government. This again, my Lord, first of all, my first submission. This is acknowledging and respecting the federal structure. That a state may take upon the state, you should not be having an allegation. Central government is imposing something which may be left to the state. That's first submission. So Lord, just keep that at the back of your mind. Second,
Now let us understand on this. Suppose we take these words as it is and a plain reading of this.
yes, my Lord.
This subsequent clause applies in case the state government undertaking with legislature decide not to conduct a TET. Ever you taken this stand that we have decided not to conduct the TET?
No, my Lord.
No.
On the contrary, affidavit says we conduct.
You are conducting.
We are upgrading.
So emphasizing this part
Yes, my Lord.
and submitting that a school 1 and 2 in the state would consider TET education, emphasizing this part, or you have to first qualify or you first have removed the rigor of first.
That is
In any case.
settle over that you are not conducting your own test.
No, not conducting. In
Prerequisite.
any case, you decided to not to conduct. So you have not decided to not to conduct.
I am decided I will conduct.
Then this will not
Then
apply.
this will not apply.
That permit me.
That is, yes, we are permitting you, Mr.
Now, my Lord, kindly take my submission.
Yes.
The submission is this, my Lord, that a state expanding a zone of consideration by taking, my Lord, if I can make that humble submission, because your Lordship put it to me while I was reading the affidavit, that I, as a Jharkhand state for Ctet, I want to bring it at the standard of Ctet. Right, my Lord? Your Lordship has laid down wherever a qualification is prescribed, you can always go for that qualification. Let me borrow that.
Not in all cases.
No, my Lord,
It's not a question of higher qualification. It's not a question of higher qualification.
No, my Lord,
It's a question. Just please don't put this
higher standard, my Lord.
humble request. Don't put this argument on higher qualification because TET and
It's not a
JTET.
qualification. No, I am
You yourself is saying it's not a qualification. One thing and JTET, CTET and JTET are saying all similar.
Yes, my Lord. Now, my Lord, I say that
So you want to open.
all right, the stand, let me put it
Yes.
to the standard, my Lord. The standard is higher, and let me put it, my Lord,
And that standard you want to put in the first affidavit, but in the second affidavit you don't want to do that. Second affidavit you want said whatever we are doing is right.
no, Lord, if that's not the position.
No,
my Lord,
it is there on your stand.
my Lord, so
We
therefore,
cannot go more than this.
my Lord,
Mr. Maninder, probably nothing is there in this argument.
no, all right, my Lord, I am going.
Nothing is there in this argument. Please.
No, my Lord, I am only saying
Yes.
that
You are saying that the discretion is vested with you under this clause, and in exercise of that discretion, if you made a concession pro Advocate General before the High Court, and if it is regarded by way of legislature subsequently, and examination have been conducted accordingly, then it cannot be put into hold by this court.
And
This is all
with one more,
full and final.
I am deeply
Anything
obliged.
else?
One more submission, my Lord, that a expansion of the consideration zone, any attempt,
Is permissible.
my Lord, it is justified and this is within the scheme of the Constitution to give opportunity.
Oh, those.
My Lord, my Lord,
Along with that, there is another preemption. What your rules says for recruitment. These guidelines will not take away the rules. The
Ctet,
statutory rules framed by you for recruitment of teachers.
Ctet,
309.
Yes, my lord.
So how those will be taken care of?
Rules are amended.
Later on.
No.
For that they have a different argument.
I am coming to that argument also.
Yes. Yes.
Yes. So therefore, the rules before the last date of the application.
All right, that argument is a separate argument.
I am coming to that.
But this will not take over everything till such time the rules to the contrary are there.
No, my lord, therefore, my submission is this. My rules for this election also provide Ctet also to be permissible.
After amendment.
From January 24,
Yes.
29 January 24 after
Yes.
the amendment.
Yes.
Last
One thing.
day, I'm sorry.
After this judgment, in reference to the judgment, rule have been amended. And the judgment is under challenge before us.
Lord, I will show your lordships a similar situation where your lordships have permitted that with
All right.
No, my lord, with,
All right.
with
So we have to be very clear and specific on the point.
my lord, your
That
lord,
how far the judgment is correct.
yeah, lord, let
If
me
the judgment is correct, then there may be a possibility your argument may be acceptable. But if the judgment we find not correct, then
I'm coming back to that. So, my lord, my first submission, your lordship saw the July order. The July order of 2023, which your lordships have seen at page 52, my lord, in the counter affidavit, the interim order, this only gives an observation for suggestion for the state to consider. And that consideration is that there are people who are the Ctet, they are already available, they are now coming before us that we should be permitted. Why should we be blocked in sitting in the entrance examination for this recruitment? You please consider it. This has been considered, my lord, and at the time when the matter is finally argued on the file, whatever decision they have taken, the learned advocate general is instructed to make that submission. The judgment only records the statement made on behalf of the state for its policy decision. That policy decision, my lord, in my respectful submission, even if it would have not taken, it has now taken the character of an amendment.
Mr. Maninder Singh, I am sorry to say, any statement made by the Advocate General cannot be said to be a policy decision of the state. If it is being just, please, no.
But I showed you a lot.
Sorry. If it is being said by the Advocate General, now the state government has taken a policy decision, and by that policy decision we are going to that. We can understand. And the state government, if the Advocate General gave a consent, no, please, we'll do it, and that cannot be said to be a policy decision. Sorry to object for it.
These are the...
No, Mr. Maninder, we cannot accept like this. After your stand taken here in this case, like this, an Advocate General gives a concession. It's a concession only. Cannot be said to be a policy decision. You read the words. Kindly read the words in the
looking at.
Oh, sorry, Mr. Maninder. No, sorry.
My lord,
Please, we can understand whatever the words. You kindly see the wordings of the judgment.
Yes, my lord.
Kindly see the wordings of the judgment.
There are 6, my lord, at page 11. However, in course of hearing, these are today, the Advocate General appearing for the state would submit that he has received oral instruction that the state is willing to relax the criteria. Now this is a policy decision.
No.
Well, that's
This
why
cannot be said.
My lord, if the state considers it, Lord, state considers it, and Lord, state considers it, inform the learned Advocate General that you please inform the Honorable Court that a
Let him say that's a policy decision has been taken by the state government and we are doing this.
The state is willing to relax the criteria for eligibility as far as the candidate having Ctet examination certificate with a stipulation that in future they would require
Come to your argument, please.
So that's my lord, that's my respectful submission. This policy decision then gets Lord,
You can take a policy decision contrary to the rules.
Lord, if the rules have to be amended, the policy decision is taken always.
Framing of rules is matter of policy.
Lord, the rules
policy has been framed. Rules have been framed in 309.
Lord, the amendment. Yes, Lord, the
We
amendment.
cannot accept. Otherwise, every day the state can do. The sovereignty and sovereign powers of the states are not prescribed.
Lord, that's what I'm.
For this purpose.
Lord, that's why I'm.
Sorry.
And just see whether there is any power of relaxation given in the statutory rules for recruitment.
Lord, if supposing, my lord, if I go by the clause 10 of the guidelines.
Guidelines will not supersede the rules.
I am not saying, my lord, I am saying my rules amendment is to come in guideline with the NCT and take the Ctet in.
That's all.
My only respectful
All right,
submission.
that is a separate argument. We'll consider whether after amendment, your cutoff date will be seen to be a good action.
So my first spectral submission ko at this stage, my lord, only at the cost
And
of
therefore, with this intent, we have put that Bihar case separately. Understanding this,
The virus.
Yes, my
we have
lord.
said we will hear that.
Lordship is right, absolutely right. So, my lord, therefore,
In that case, the situation would be different.
my lord, therefore,
Because in that case, we have to look into the regions, statement of regions and objects. What was the region in that?
yes, my lord.
That is entirely a different thing when we are examining the case of the varies of. Anyway,
Now
so
therefore-
carry on with your
Proceed now.
argument. Yeah,
I will, my lord, I would seek your lordship permission when I am arguing the next point that you can't change.
come on the next point. We have understand your point. We have already clarified you. We have understand your point.
Yes, my lord.
So please come on the next point.
Now, my
Please,
next,
Mr. Maninder.
yes, my lord. My next submission is, my lord,
Yes, please.
that the amendment having been made in January 24. Now, my lord, here,
That amendment.
29 January.
yes, my lord, that has been
Which
placed
page?
from the court.
This is
counter
The counter affidavit.
outside.
Yes, my lord, page 60.
60.
Yeah.
Page 60.
29 January.
Which was modified in the necessary.
29th of January 24. Under powers conferred to proviso to Article 309 of the Constitution, the Governor of Jharkhand hereby makes the following amendments in the Assistant Teacher Cadre Appointment so-and-so rules of 2023, which was allowed originally 22 and 23 were also amended. From following amendments are there, the rule made under the clause A. The rule shall be called so-and-so amendment rules of 2024. And then, my lord, for the present purposes, your lordship will see page 63, clause 6 and clause 7, the middle portion and the latter part. That's not in subclause capital B of 6. Which is for class 1 to 5, my lord. The para is with the in addition to the above, my lord, which has been added by the amendment.
Where is that?
My lord, at page 63.
Oh, 63. Yes.
So sorry, 63 clause 6. Then, my lord, capital Roman B. And after that, your lordship is qualified in teachers eligibility test JT Act, my lord, which is the original provision. And this in addition to the above. This has been added, my lord, in the rule. I just permit to read this, my lord. Such residents of the state of Jharkhand. That's a Bindal has got.
Yes, we have.
63 in that subclause capital B, the first para is the original provision. Amendment is followed in addition to the above. In addition to the above, such residents of state of Jharkhand who have qualified in the central teacher eligibility test conducted for class 1 to 5 under the guiding principles formulated by the NCET or qualified in the teacher eligibility test conducted by the neighboring states of Jharkhand are included in the appointment procedure on the post of assistant teacher subject to this condition shall be mandatory for them to qualify JAT in a chance available within and 3 years after the appointment. And with regard to my lord, the higher position, kindly see 7.
That is for higher class.
For my lord, see
1 to 5 and 6 to 8.
yes, my lord. See, my lord, for
But what is
addition.
the definition of neighboring state?
my lord, there is no separate definition given.
Then how do you define it?
But like Bihar would be the neighboring state, my lord, from where they have
A
emanated.
matter of choice, anybody can say Nepal also is we consider our state.
Have you put in some states?
It's not vague then.
But any, my lord, of course, my lord, your lordship is right. Whether any guiding principle is there which is to be taken.
These are the rules.
Yes, my lord, I am saying so. I bow down to your lordship's observation.
And these will have to be vague like this.
There is no definition, my lord, which has been given. So this has been left. So this boundaries in the neighbors are, my lord, boundaries. So, my lord, maybe that is the only possible explanation which I can give.
Jharkhand, Bihar,
Bihar,
Bengal.
Jharkhand, we can understand.
Jharkhand will
Come then attaching with the Orissa, attaching with the Andhra Pradesh,
Connected.
attaching with the West Bengal, Palangai. They don't know the language even of local. Can we take into a neighboring state? Then you see the Bihar, then these are the state connecting Uttar Pradesh at first side. Another state comes to that West Bengal, another state comes to Orissa, third state comes to Andhra Pradesh.
Yes,
And their languages can be on saying the officer it would not be neighboring state.
Plan दिखाना इस पर.
On saying your officer it would not be neighboring state.
India का नक्शा दिखाओ इस. India का नक्शा.
Your officer would keep something in your mind, keep him in his mind. We are not concerned with that.
My lord, the Bihar is there, West Bengal is there, Odisha, and my lord, the Chhattisgarh.
Chhattisgarh.
Yes. These are the 4 states which are, and my lord, the languages I'm told are the common in these states. Maybe
How you can say so?
some different.
How is it that Orissa? How? Nobody, you go there and nobody speaks.
My lord, on the borders, my lord,
No, nobody speaks even.
Question of border.
Go in West
but
Bengal,
the
nobody speaks.
languages are overlapping, my lord, your lordship.